Thank you again to everyone for the opportunity to address you and share the challenges in using law to achieve sustainable development. It's a broad topic. I was also told to share and put in the presentation about the work that we do. So I've tried to put that in. The last day also was spent in hearing a lot of interesting studies that each one of you are doing. So keeping that in mind, I've also tried to, put in some slides or will share some of my experience in dealing with those issues. So with this, I'll try to, keep to the time. So I want to be sure that I don't just overstep. So what I'll be doing is, as a lawyer, my principal work has been to take up issues before the courts. And before I deal with what cases that we have taken up and all of it, well, it's been a roller coaster ride for us, and I think we are in some of the most pressing times at present, dealing with environmental litigations and environmental justice issues. I'll begin with somewhere around the 80s and 70s when it's all started. And so whether we regard law as an instrument to protect the environment is an important question, because if you look at it here, many of the countries across, law was actually an instrument to exploit the environment. They said something very interesting is the fact that when law is enacted, what is it? There's one is called rule of law, and there is another concept called rule by law. That means if you make every illegal act legal, then you can actually operate within the parameters of law. So therefore, the issue comes in is to how much of importance we want to give to law itself. And that becomes a very important aspect to consider, because when we look at legal systems across, I can broadly say in India, well, we have the pre-independence time, that is pre-47, where you had the Indian Forest Act and many of the laws which are still in vogue in Pakistan, in India, in Bangladesh, where the principal focus was how do you exploit the forest in order to generate timber. That's it. And which ultimately is for the purpose of revenue. Post Stockholm 72, there were changes when issues like conservation, aspects like protection started coming in. And then we have the after the 90s, when climate change also started coming within the legal framework. I'll start here. Well, many of you may be aware, some of you may not be aware, but the genesis of India's environmental law actually had its origin in Bonn, right? And this man here is Brandis, right? He was the first Inspector General of Forest in 1864, right? He was born in Bonn. He studied in Bonn, in the University of Bonn. And the entire forest governance in India is actually not the creation of the British. It was the only department which was actually run by the Germans for a fairly long period of time. So Brandis became what is the oldest existing post in India, which continues till date, is actually the Inspector General of Forest and the Surveyor General of India. And so Brandis became the Inspector General of Forest of India, which included Bangladesh, Pakistan, and then he was also Inspector General at the same time of Burma. And he introduced the whole concept of what is called scientific forestry, which principally meant that you replace natural forest with timber yielding trees. And he was first, and if you see what I've written here, this is from a textbook of the Central about Brandis' contribution, right? They say, well, he was appointed as Inspector General. He trained people, realized that proper legal system has to introduce to manage the forest, and people has to be trained in the science of conservation. That's a very important point. The whole belief was that the entire forest in which local communities and all were there were not really managed for conservation and protection. So therefore, they had to introduce law in order to protect it. From whom? From the local community themselves. For whose benefit? To benefit the British colonial rulers. That's how, but the narrative is still part of it, so well entrenched that school books to, civil services textbooks to all remember that, well, he's the father of tropical forestry. He came in and saved it. Well, he has contribution to make. One doesn't, it was a time when, you had different type of peoples ruling India, but at the same time, there was certain contribution. For example, one of the best books till date of trees in India called The Indian Trees is actually authored by him. He wrote it and published it when he was 83 years old. Right? It still remains one of the most pioneering work on Indian trees till date. But there is, I will always say, a born connection to the evolution of environmental law and forest laws in India. And, people are here. Maybe it'll be interesting to find out if there is some remnants of any of his work here. Is there? Now, what was significant was the Chipko movement in the 1970s. Incidentally, in 1987, Chipko movement, which was actually hugging the trees. It was a movement by the villagers in the northern Indian state saying, well, you should not cut the trees, right? Because the tree belonged to us. So a sports company called Simon Sports wanted to take the trees and cut the trees for making cricket bat. So the villagers came in and said, well, you have no right to cut the tree because the tree belongs to us. Now, this is the narrative that was all one celebrated. And incidentally, Chipko movement received the Right Livelihood Award in 1987. Right. So I've taken it from the Right Livelihood page itself for using it. But what is not always shared about the Chipko movement was that it was not really about saving the tree. The Chipko movement was about who has the right to cut the tree, who has the right to benefit from the cutting of trees. So there the people ultimately did cut the trees, right, and sold it, saying the benefits one must come to the local people. It cannot be taken by the outsider. So it was not a movement about the rights of the tree, as was popularly shared, that people gave their life and hugged the tree saying, kill me or kill the tree. It's either. It was not. The story of Chipko was about it belongs to us and we can only use it and not you. So in a way, it was more of a peasant movement than a rights movement, that is a tree rights movement that one can think of. But it marked a fundamental change, that environmental issue is about rights. 1984, we are very close to the date. December 3rd is a black letter day, right, in India's environmental history. That's about nearly 4,000 people died, more than 50,000 people crippled in what is called the biggest industrial disaster, the Bhopal gas disaster. But what is interesting here in terms of law is that I regard Bhopal disaster even more serious from the legal aspect. When the Bhopal disaster happened, a methyl isocyanate leaked, killing more than nearly 4,000 people. The number of people who were crippled is nearly about 40,000, 50,000. We still don't have the numbers. It was a American company, Union Carbide. And the interesting part was that the CEO, the head of Warren Anderson, who headed the company, was allowed a free exit out of the country with no criminal liability. And the interesting part of this whole case was, because when I talk about law, it will be relevant, is that the case against Union Carbide for criminal liability was actually filed by the government of India in the District Court of Washington. And they decided not to file the case in the court in India. And when you go to a different jurisdiction, you have to first prove why have you come to the courts in the US and not to the courts in India. So the government of India went to the courts of the US and said, well, we do not trust the court of India. They actually said it on affidavit because the judges have a hangover of the colonial past. And in a complicated matter like this, they are not well trained to adjudicate on environmental issues. They are not innovative. And therefore, the courts in US should actually try the case. The judges in the US, Justice Keenan said, well, sorry, your judges are well trained. You have an independent legal system. Your constitution is there. Go back to India and file the case. So finally they came back, by which time almost all the evidence vanished, right? And finally, virtually nothing happened to the company. So if you look at it here, it was a black letter day so far as Indian history is concerned. 1980s onwards, we see growth of civil society movement. There's been a rise of what is called public interest litigation. It also led to enactment of new laws, regulations, the Air Act, the Environment Protection Act, the and there was a lot of concerns for the first time coming out of the impact of pollution. Because we had a law of the British time called the Indian Easement Act, and that Easement Act gives right, saying that every person shall have the right to pollute every stream and river, because it was seen as a sign of development. That if you pollute, you develop as a nation. Now, so these concerns started coming in. And one of the very important place or the role in the entire environmental movement in India has been the Supreme Court of India. And there's a particular provision that exists in the in the Indian Constitution that has been creatively applied by the courts of India in a manner which has not happened anywhere else in the world. And that is this Article 142 of the Indian Constitution, which says that whenever the matter comes before the Supreme Court of India, it can pass any order in order to do complete justice. What is complete justice is not defined. So whenever a matter comes before the Supreme Court, in order to do complete justice, it can pass any order, and the order so passed need not be in accordance with the statutory law. And there's no better example than when we look at in terms of forest itself. So we had the Forest Conservation Act of 1980, which says that forests must be conserved. And if you want to divert forest land, you must take the prior approval of the federal government. The problem was, for years, the word forest was limited only to areas which were notified as forest in government record, that is reserve forest, protected forest, national park and sanctuaries. The Supreme Court said, we invoke powers under 142 and say the word forest must be understood in terms of dictionary meaning. So across India, in terms of whatever and whichever area fulfills the dictionary meaning of forest, it will be treated as forest. So today, all we need to do is look at Google Maps, see whether that area looks like a forest. And the moment it looks like a forest, the provisions of law apply, irrespective of whether it is a privately held land or whether it's a government land. One of the important provisions that they applied is Article 21, the right to life, has been interpreted very widely by the Supreme Court. So right to life, it says no person can be denied of personal liberty or life without due process of law. The courts have interpreted right to life to include right to a balanced ecosystem, the right to clean air, right to clean water. And about 5 years back, they said the right to life under Article 21 includes the right to sleep, right? So therefore, noise pollution also affects a human, because deprive a person continuously of the right to sleep, you deprive a person of the right to life. Locus standi, which is one of the very important concept, is what is your standing to go before the court? Under the Indian system, the court generally never asks you who you are if you raise an issue of public concern. So anybody, anywhere can raise an issue with regard to environmental and other matters before the court of law, raising that I have a fundamental duty to protect the environment, and therefore I need not show how a particular decision affects me. There's an issue of continuing mandamus in law, means that the court basically oversees and looks into the implementation of the law itself. Suo motu jurisdiction is a very important concept, which means basically that even if there's no party involved, the judge can read a newspaper article and say, then based on this, I take suo motu cognizance on my own and pass orders with regard to this case. Now, few of the important developments that I want to definitely cover here is that there was a lot of presentation about rights of local communities, right? About what right do they have when it comes to these kind of forest land over wetlands, over water. India enacted a law in 2007 called the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act. It's a landmark law which recognized that a historic injustice has been committed against forest-dwelling communities who have traditionally been living in forest areas, but whose rights have not been recognized under the law. This law says that no person whose livelihood depends on forest can be evicted or their rights interfered with till the process of determination of rights are completed. Every village in India will have a general assembly called a Gram Sabha, a village council. That village council will find out as to whether you are legitimately in occupation of a forest land or not. And that village council is a general body of villagers themselves. And there are about 18, 20 evidence which are there, which you can submit to show that you are in occupation of this forest land. And it can be as general as stating that if there is a village elder who makes a statement that this person has been in occupation of forest land, that will be taken as evidence because they recognizes that every evidence need not be in a written form. If you have old structures, a temple, old trees, which can show that this tree has been planted by your ancestors, that is a proof of your existence itself. And this is what the process had done. Villagers will go, make a claim themselves, sit around a tree, decide on what is the land under the occupation, and very important is how much of land has on which the community depends on for their livelihood. So there's an individual forest right and there's something called community forest rights. It's given. And if you see, this is just from the website of the Ministry of Tribal Affairs itself, that this is the number of CFR, that is community forest rights, individual forest rights, and how much land areas have been distributed from 2006 to forest dwelling communities who are regarded as encroachers earlier. It has been one of the very, very significant development in terms of right-based approach towards conservation and protection. Now I'll come to the area that has been a focus of my work is India's National Green Tribunal. And India happens to be one of the few countries which has a dedicated body called environmental court called the National Green Tribunal. And interestingly, it was set up using the Stockholm Conference as well as the Rio Conference, saying that Principle 10 requires access to justice, public participation, and information in matters concerning the environment. So we now have a functioning National Green Tribunal. That's one that you see is the Delhi one. And we have a lot of rhesus macaques all across in the compound itself. And we have 4 of them across India, 5 of them across India. It hears about close to 200 environmental cases in a single day. And one of the very important thing that the NGT did, the National Green Tribunal, was to make it clear to everyone that environmental law is really a serious business. And if you violate the law, you will face consequence. So when the NGT started functioning, it was a standard process of the government to ignore, saying, well, it's at the end of the day an environmental court. Why should we take it seriously? So the Green Tribunal, which was a civil court, started its operation from 16, 17, started in 11. But if you see, I just did a Google search and just put in page. First thing is it issued arrest warrant against all senior officers. And my friends from India would know that what a chief secretary or director general of police means in the government hierarchy. So just the fact that you issue a warrant of arrest, you may not do the arrest, but just say bailable warrants of arrest is enough to shake the bureaucracy. And so for the first time, what we found there was we could go to the court as a lawyer representing local communities, tell the government to respond saying they have a problem, the government's first one is, we don't care, we will not respond to them. The court next hearing will say arrest warrant issued. And so you have a police officer going to the highest functionary of the state saying, well, you give 25,000 rupees, we'll grant you bail. But that was enough for them to suddenly take environmental issues seriously. One of the first significant judgments actually happened, started from the NGT, went up to the Supreme Court, is with regard to this case concerning a UK-based mining company which was owned by an Indian, which is owned by an Indian, called Vedanta. It's a very sacred name, but doing just the opposite kind of work. It was involved in mining in an area called the Niyamgiri Hills in the state of Orissa. They wanted to mine bauxite. And that particular hill is regarded as sacred by the local community here, which is 8,000 in number. And in a country with 1.4 billion, 8,000 really should not matter. And that's how the company came in, said we want to do bauxite mining. And ultimately, we won the permission to do the mining. They got the permission. We challenged it in the court of law. And, I can share, it was a 10-year battle in the right at different courts and finally in the Supreme Court. And their first argument was that by mining will bring in development. Right. And the whole argument was that bauxite mining is critical to improve the human development index there. And in order to support the stand, they said, actually, the total area of mining that will be mined in this entire forest area will be only about 2% of the total land area. So if 98% of the forest will be remaining untouched. So as a lawyer representing it, this was way back in 2004, we were faced with a very strange problem because that time you did not have Google Earth. You did not have any quick means to verify that information. So when we went back, they said, well, 2% of the total land area, and this is on the top of a hill. Bauxite is usually on the top of a hill. They said it's 2% area. We looked at all the data, came back to the court. I said, give us a day to verify whether this 2% is true or not. I came back to the court the next day and said, actually, they've given a false information. The actual area impacted by mining will be actually 0.5%, right? And not 2%. So the judge looked at me and said, is that your argument? Just to prove the data is incorrect, you want to say that it's actually not 2% and 0.5%? I said, yes, it is 0.5%. Then he said, what's your argument? I said, what we are talking about is impact. When a bullet hits a human body, it also impacts 0.5% or 0.2%. Right? It does not affect 20% of your body. When somebody slaps you, it may affect 5% of your body. But the impact is much less. So let us not link percentage with impacts. So if this is a bauxite hill, it is a source of 5 rivers on which the livelihood of all the communities is based. And therefore, you cannot take away the source of livelihood. And second most important is that they regard it as sacred. Under EIA environmental impact assessment, cultural impact assessment is also an integral part. So the court recognized that. And for the first time, the Supreme Court said that you may have got all the approvals, but you must place the proposal for mining before the village council. And there were about 25, 30 village council, Gram Sabha as we call. They will decide as to whether mining should be allowed or not. And I can tell you all 30 of them rejected the mining proposals, said no to it, and it became India's first environmental referendum. In the India's northeast, right, there was a very interesting case of, if you look at it here, there's 2 birds that you see. This is the black-necked crane. Now, why I'm referring is black-necked crane as per IUCN is in the vulnerable category. But the black-necked crane comes to the Indian state of Arunachal Pradesh during the winter time for wintering only. Right. I was approached by the local community called who are basically Buddhist, who regard the black-necked crane as a reincarnation or an embodiment of the Dalai Lama. was regarded as sacred guru of theirs. So they approached stating that, well, this dam is coming up in the site where the 7 to 8 of this black-neck crane actually come for during the winter season. And the environmental impact assessment was done during the summer season, therefore did not record the presence of the birds. So therefore you have to, we challenged it saying, well, it is a fraudulent document. This study should be a year-long study, and this presence of bird is very critical. So have the developers looked into the impact of the black-neck crane because of the proposed hydropower project? We challenged this before the National Green Tribunal. It took us 3 years. And just to share with you what happened really was very interesting. For some strange reason, for the 2 years or 3 years that the case went on, the birds decided not to come during the winter season. Right? So here we were in the courtroom arguing the matter, and the opposite side, well, there are no such birds. If it comes, let's wait for December. So never came. Next year, December also happened. The birds were not there. The judge really got fed up. So the next year, after a year and a half, said, well, I'm now reserving the order, which in legal language means they've heard everything, and then just start writing the judgment. And so said that we'll give you 2 more days to make your written submission because you have not been able to prove that the birds are there. I said, fine, we'll make our written submission, because we were depending on secondary literature, because there were enough secondary literature to show there were beliefs of the people. And I unfortunately could not locate that one in my other slide. I don't know. But just before the last date of the hearing, the birds decided to come. Right? And we had the Times of India, which is the world's largest circulated English daily, coming with the headline saying, rare birds arrived at the hydropower site, lay claim to the project site itself. And that presence changed the destiny of the case. It became among the first case where about a 700 megawatt power project was stalled because your studies did not take into account the impact of birds. But there was a larger issue. The larger issue was that that area was sacred to the local people. And also very important to remember is that when we call it sacred, whether it was the Niyamgiri case, the first case that I told you, or the second one, they are not concerning the 85% Hindu majority. They are concerning a population which is not Hindu, but less than 0.5% Buddhist population, and the other one who are nature worshippers. But the court recognized the right, and they suspended the approval that was there. And I'll just try to wind up in a few minutes. And surprisingly, as is expected, well, a lot of articles started coming out saying, well, why are the courts interfering into India's economic growth trajectory? How come butterflies, cranes, macaques all are figuring in the decision making of the courts? And why are we not allowing these projects to go through? Well, our answer is, well, not all projects are challenged. And if you lie and do not take into account these facts, they are going to be ecologically disastrous. And our own entry into the litigation, especially for hydropower, actually started in 2004 and 5, when we took up a challenge on behalf of the local community in Sikkim, in the eastern state, who were opposing the setting up of a hydropower project called the Tista 3 hydropower project. We took it before the court, and like many cases, I've shared some of the victories, but most of us, we're not always successful. And there we raised few grounds. First, the Himalayas are extremely fragile. And all the studies have never looked into what will be the impact because of glacial lake outburst floods. You have not looked into the fact that because of climate change, the snows are melting. These have to be taken into account. And we said before the court that these projects are not ecologically viable nor environmentally feasible, economically feasible. So therefore, you should cancel them. The court refused to interfere, saying what? In all of them said the principle of sustainable development requires that we look into energy access, we look into human development, we look into education, which is only possible if you have electricity. Yes, you have electricity, but not at the wrong places. And we lost the case like many other cases. And 5th of October, right, 2023, disaster struck. And this dam became the first dam in India to have completely been washed away. It is a 1,200 megawatt power project, which is a huge project. And if you see, this is what it was. It took 10 minutes. 10 minutes is all, because what we are building there are basically castles of sand. It doesn't take more than 10 minutes for an entire dam to go. This is there. This entire project work wound up. So what we are saying here is something which is very, very important, is that when we take up litigations here, the first charge that is put against anybody who takes up environmental cases as a challenge is that about 10 years back, you are anti-development. Today, you are anti-national, right? You are against the national interest. And so therefore, about 10 years, 5 years back, well, as lawyers, we could freely do our work. Today, the greatest challenge is that there's been a criminalization of litigation. Almost all the NGOs who have litigated and gone to court, including our organization, have all lost their charitable status. We have been prohibited from receiving foreign funds, right? And we have been prohibited from, interacting or getting in any new money to do all this litigation work. And all those who have actually done it are facing action, both under the Income Tax Act as well as under Foreign Contribution Regulation Act. You can read about it. So it's become a very, very depressing scenario. And this is the greatest problem, is that in all the instances, people were using constitutional means to raise dissent. It is not that they were protesting in the roads. It was not that they disrupted the process itself. They went to court because the parliament had created a forum for them to go. So therefore, this criminalization of litigation is also an outcome of the fact that people largely succeeded in protecting and asserting their rights through use of law. That has also been an update. And I think what it has happened here is that we need litigation, we need the court system largely because of the fact that today, in absolute numbers, India has the worst quality so far as air and water is concerned. It's the worst quality, because when you compare with other countries, the population is still lower. But in absolute number, we are the largest. So if you look at 20 most polluted cities in the world, right, 15 will always be in India. But what is important there is to recognize that when somebody asks me, why is it that 15 out of the 20 most polluted cities in the world are in India? My answer to that is simple. I said, the only reason why 15 out of 20 most polluted cities of the world are in India is because out of the 4,000 cities that we have in India, only 1,000 of them have monitors to monitor air quality. The rest of them do not have monitors at all. When we say that the air quality index is at 999, right? We were discussing, why is it at 999? When you are at Frankfurt and when you're in Berlin here, at Bonn, the AQI index is at 2025. In Delhi, it is 999. And when you are asked, why is it at 999? The answer we give is, well, the machines can only measure up to 999. Right, that is why it is at 999. So I'll leave you with, I say one has to be always optimistic, right? And I was reading that tomorrow, day after tomorrow, I go back to India. And is there any good news awaiting me? Because the air quality is really bad. And this is what we get to read, right? So this is where poor is a sign of improvement, right? So this is the greatest achievement that we can have, that air quality has improved to very poor, right? So So, and I really don't know in terms of where it is, but I can only tell you that we still have a very vibrant civil society group. We still have a very active citizens movement. And I still hopeful that using the best constitutional means, citizens groups and others will be able to creatively fight for a more healthier, greener, and a just planet. I can go on, but I'll stop here. Thank you.